First and foremost, it's great to see everyone, and thank you so much for joining us today. It's great to see everyone on this. It's been some time since we've done a member open house, and we're thrilled for today. I want to introduce myself. My name is Brian Sheffield. I'm executive producer here at Wonderful Machine. I've been with Wonderful Machine since 2019. Through producing and a previous 18-plus year freelance photography career, I've concepted, planned, and executed photography all over the globe for brands, agencies, and publications. I have a BFA in photography from the School of the Museum of Fine Arts in Boston, and I live in the Philly suburbs. Also on the call with us today is Andrew Souders, who's a senior producer here at Wonderful Machine. Andrew's been with Wonderful Machine since 2019, calls Philadelphia home. He studied at Temple University Tyler School of Art, where he found his way into the photography world at first as an assistant. So for the last 12 plus years, Andrew has also traveled the globe working on productions, both large and small. Here at Wonderful Machine, Andrew and I work with photographers and clients every single day to support their upcoming projects. In addition to producing photo and video shoots, we create custom project estimates for photographers, where we review the scope of work, recommend appropriate creative and licensing fees, and production expenses, all the while reviewing the client purchase orders and scopes of work. Together, Andrew and I have built close to 400 cost estimates this year and reviewed countless more. So joining us on the call today are Joel and Evan from SRIP Law. SRIP Law is a US and Columbia-based firm that represents photographers, artists, inventors, writers, musicians, and other creatives in intellectual property infringement transactions and litigations involving copyrights, licensing, and anti-counterfeiting. SRIP Law has 50 employees across their offices in Florida, Atlanta, New York, Indianapolis, Tennessee, Texas, and California. On the call with us today is Joel Rothman, who's a managing partner at SRIP Law. He founded the firm in 2012 and has been practicing law for 35 years. Joel's a former Bronx prosecutor and currently represents clients in trials and appeals, and is a self-described frustrated creative who loves looking at beautiful images. Also with us today is Evan Anderson, partner at SRIP Law. Evan joined the firm as a partner in 2022. Previously that, he worked with Carolyn Wright, aka the photo attorney, for years, and started his own practice in Atlanta focused on defending intellectual property rights and promoting the awareness of copyright law and licensing best practices. Evan leads SRIP Law's photography and copyright infringement practice. So Wonderful Machine incorporates terms into each quote that we create. We've written these terms to fit the needs of photographers and videographers, and we use them when we build quotes on behalf of the creators. We've recently updated these terms, and Joel and his firm have been very helpful in reviewing, refining, and making sure everything is sound. We're thrilled that they can join this call with us. So today we're going to discuss these terms we use when building quotes when working for photographers. We'll review what that means and how a good terms and conditions section in your quotes will set you up for success. We'll provide a quick overview of how we structure price quotes and then dive into the terms to discuss each clause in depth. Just a few housekeeping notes. Feel free to use the chat as we're talking and throw any questions in there that might come to mind so we can address them at the end. I'm going to now hand it over to Andrew to walk through our recommended price quote structure.
Yeah, so before we get into the nitty-gritty of the terms and conditions, I think it's important to understand how a price quote functions as a contract. These four components that you see on the screen here are going to work together to kind of define the scope, the rights, the costs, and the rules of a project. The job description is basically the who, what, when, where, and how of that project. And that's going to be an explanation of what you're being hired to create and under what those circumstances are. A job description is going to keep both you and the client aligned on that scope from the start. And because everything in a price quote makes up that overall contract, this section is also legally meaningful. The licensing overview, which is often part of the job description, is an outline of the rights the client is receiving. So that could be the territory where those images are going to be used, the quantity or how many images or deliverables there are, the usage and how those images can be used, and then the duration, which would be how long those rights last for. This is the part clients tend to misunderstand the most. So being explicit here prevents a lot of issues later on. Fees and expenses is exactly that. This is going to be your full cost breakdown. That's going to include creative fees, licensing fees, crew, equipment, all the other production expenses. That's going to show the client the total cost to execute this project and the value of the rights that you're granting them with your licensing. This is a working component of the contract as well, and it sets the expectations for scope, budget needs, and what that client's going to be invoiced for. And then finally, the terms and conditions are going to cover the structural rules of the agreement. So everything that isn't in the job description, the licensing, or the pricing. And that's going to include things like definitions on different types of use, payment terms, copyright, indemnification, cancellation, postponements, what happens if there's a weather delay, delivery and post-production parameters, and all the legal and operational guardrails that protect both parties are going to live there. Now, this slide is an example of a price quote that Wonderful Machines built, and this kind of shows you the actual structure that we use in our price quotes when we're working with a photographer or when we're producing our own projects. A well-written price quote is going to be more than just a budget. It's going to be kind of a guide for the entire project. It's going to lay out that job description, fees and expenses, and those terms and conditions that will govern how this job is going to run. Strong contract's going to give you and your client an opportunity to support you through every stage. So negotiating, pre-production, the shoot itself, and then even into wrap. And it keeps everything transparent throughout that whole process. The client contact today might not be the person handling that project tomorrow. So, people change roles, agencies shift, they reorganize, but a clean and well-structured contract makes that project understandable to anybody who needs to reference that later on. Whether that's a producer, a finance team, legal, new hires, the contract's going to need to hold up to that, those people, regardless of who's reading it. And then a clear contract is really going to force both sides to be explicit about their expectations as well. It's going to remove any assumptions. It's going to reduce surprises, and it's going to keep the project aligned from start to finish and even after wrap.
Awesome.
Get back over to Brian here. Yeah.
Thanks, Andrew. So as we can all see on the screen here, this is a 3-page estimate where about 2 full pages here are the terms and conditions. So what we're going to do now is go through each one of those separate clauses and paragraphs separately and kind of break it down and discuss what that all means and how we put those together to help with creators. This first section here goes over the agreement. Basically what it says is that this is our agreement for the project, and it also references that the client will sign the document. This is important that when and if disagreements arise, you have a clearly written and signed agreement that's going to provide a lot of incentive for you and your client to fulfill all commitments to each other. Next section we go through here is price quote, and we're describing what a price quote is. We look at this in 2 ways. There's an estimate and a bid, and those are 2 options. An estimate is where the costs can fluctuate based on actual costs, and a bid is a fixed agreed upon total. Everyone on this call has probably seen versions of both, and clients ask for both. Getting off track a little bit here, but I think it's really important when a client reaches out for a quote, ask them what they're looking for. Do they want to see an estimate? Do they want to see a firm bid? What we also note here in the last bullet point is that the price quote has an expiration date. This is important. Things can change. Your expenses can change. Especially what we see happen most often is travel costs can go up or down. So that's really important here to put a expiration date on the agreement. Joel, Evan, do you guys have any thoughts on this clause?
Well, I was a little before I begin though, I need to say hi, Alan Blakely. we represent Alan. I just looked up your cases. Looks like we have a lot of closed cases, but at least 10 open cases. If you need anything, reach out to me and Evan. Let us know. This confused me because you know, I didn't know what an estimate was versus what a bid was versus what a price quote was, and that segues into the other issue, which I think is probably the most important, is you know, defining terms. So, you know, we do a little bit of licensing and contractual work, not a lot, because we're very busy suing people, often for using works, using photography in ways that they didn't have the authority to, or they thought they had the authority to and didn't. So, and that keeps us very busy. But I think the thing we see most frequently is when we file a lawsuit and there was an agreement, and we would never file a suit if it was arguable that the use was encompassed by the agreement. But it would be a use that was just not something that was contracted for at all. Couldn't possibly be interpreted to cover that. And the answer we get from the opposing party or their counsel is, but no, we have those rights, right? And sometimes it's an argument that they can make, but almost always there was at least a little bit in terms of the failure of communication, so that everybody understood what a term meant. Okay, it's almost as if the cases where there was no contract, but somebody had a commission to take images, take pictures, and there was no contract, that those are easier cases in many ways than if there is a contract. Now, of course, with no contract, it gets very difficult for a lot of reasons. So I don't want to recommend anyone going out there and not trying to paper the transaction. And that's why, you know, Brian and Andrew are busy all the time. But, you know, it really does matter and especially now when there are so many different types of uses that there never were in the terrestrial world, but now there are millions of different types of uses online. It really does matter to define those terms and to define what, you know, what an estimate is, what a bid is, what a price quote is, what the necessary requirements are for each of them. And if you do that and you do it clearly, then hopefully you don't have problems.
That's right. That's right. Absolutely. Thanks, Joel. This next section here we talk about is sorry, to go back to what Joel was saying, to talk about terms and definition of licensing. That is agreed, extremely important, and we'll get into that in a couple slides, and it takes up the bulk of this conversation. So this section here is invoicing and payments, and this is something that's extremely important to every photographer. So what this is saying, that there will be an advance retainer paid to start work. This is not a deposit. This is an advance retainer going towards this project. This needs to be paid up front. We always recommend, you know, at least 50%. I think there's going to be some situations where that number can change. You know, potentially there's a $200,000 job production where you're only making $5,000. So you want to get, you know, an advance that covers your needs. This section also states that the client is going to pay within 30 days of invoice. That's kind of the normal time. Everyone on this call has probably seen clients sometimes say 45 days or net 60 or net 90, for God's sake, sometimes. All that needs to be agreed upon, but we'd recommend net 30 as the normal amount of time. This also states that the client will be penalized if they don't pay on time. This is also acts as an incentive for the client to pay promptly as well. So in this case, we have a $100 a month handling fee and 1.5% interest if the client does not pay on time. We also note here that the quote does not include sales tax, but it will be added if necessary. Sales tax rules are so varied state to state, and sometimes locally. It's just easier to state this as a whole, that it will be included later if need be. Currency conversion. This is something that we add into these new terms versus our last ones. And this is basically saying that the estimate reflects exchange rates at the time it was created, and the invoice will reflect the current rate at the time of invoicing. If it's a bid, we're saying here that the creator will accept the risk of exchange rate fluctuations. So this is a situation where, you're hiring a third party in Europe or something, and as you put together the estimate, it's 10 grand, but then when you go to pay the person, all of a sudden you owe them 2 grand more because of the exchange rate. If this was an estimate, that's covered, and you're gonna be able to bill the client for actual expenses.
Can I just, another way to do that is just agree on the rate. If when you start the project, the euro is, $1.05, which it's not anymore, then just agree. The exchange rate's going to be $1.05. Okay. And then that way, if it changes, your costs and the other side's expectations won't change. The other thing I wanted to mention, what we usually put in the prior term with invoicing and payments, what you expect to see actually in your agreements is in the one after, which is, but I see it in different places in different agreements. And that is any rights you're getting to work, any rights at all, okay, you don't get them until full payment is made.
That's right.
So there is no more important term than that, as far as I'm concerned. Okay. If all your standard invoice says is your rights are conditioned upon full payment, that's all it says, that makes me happy. Because then I can sue them for copyright infringement when they don't pay you.
Mm-hmm.
Because they didn't have any rights. And, in one case, they used the work as a mural in a nightclub, but it was like, it wasn't photography. It was actually, it was a painting. Okay. But no difference. Okay. And I said, hey, it's too bad, but I'm going to ask the court for an injunction to tear your wall down.
Mm-hmm.
And payment came very quickly.
Mm-hmm. Yeah, that's great. And that one of the things we say too in invoice payments, it's between whether it's the copyright infringement by not paying or the late fees, those are good incentives to have the client pay on time. So we do get into exactly what you're talking about here in copyright and licensing, which is that the creator owns the copyright and the client needs to pay in order to use the work. If the client wants to use the work in a different way, that's described here in the quote, they need to pay more. We also added a line here that the work cannot be used in connection with AI without written permission. And that's becoming more and more important to a lot of photographers out there. We've also added a line here that the creator may use the work for their own self-promotion after the client's first use or 12 months. And that's irregardless of any exclusivity clauses. Within this too, as talking to photographers in my life, it's kind of become commonplace that I've seen that photographers don't register their work with the U.S. Copyright Office unless there's an issue. Joel, Evan, you guys want to spend a minute or two discussing quickly why prompt registration is important?
Yeah, Crystal asked a question about that. So, if there is infringement, in order to file suit, you need to have a registration. That was my U.S. Supreme Court case in 2019, and fortunately, it didn't go the way that we'd hoped, but that is the rule.
So in order for the courts to see the case,
You have to have a registration in hand. And so now that means that, yes, you could register after, but if they use the work in a way that they weren't authorized to use it, and you don't register it until after, you don't have statutory damages and attorney's fees. And we represent photographers on a contingency basis all over the place because we have the ability to recover our attorney's fees. Bill, you're anticipating where I'm going. So registration as a habit, as part of your workflow, really does help. So let me explain, because I think often people don't realize that there have been a lot of changes at the Copyright Office in the last 10 years. And so if you don't have experience registering something for some period of time, then what you may find is things are easier and cheaper than you realized, or than it was before. So you can register groups of photographs. You can register them either as published or unpublished. And I don't remember exactly, and maybe Evan, if you know, you could jump in here, or but certainly if the photos are unpublished at the time of the registration, there's a lot more flexibility. And the Copyright Office, copyright.gov, lots of information there. You can also do the registration online. It used to be, it might not be the case anymore, that there wasn't a limit to the number of unpublished photos that you could register. Now, what is published and what isn't published? Well, if you're taking the photos for, a magazine spread like Vogue or something, and the magazine comes out and the photos are in Vogue, okay, then they've been published, right? But if what you're doing is you're registering all the images that you're going to hand over to Vogue from the shoot after, you've already taken them, but before Vogue's done anything with them, then they're unpublished at that point. So you could pull together large groups of images from different projects during different periods of time, and perhaps do it once a quarter. John Fulton says a group as big as 750 images. So, if you combine them all together into a single group and register them like that, then what does that cost you? It costs you a little bit of time to put the registration together. And if they require a spreadsheet, which I forget whether published or unpublished, if they do, but those are easy enough to create, and you upload them and you pay $75 and you're done. Mm-hmm. So that's we love to see that because and the other part about it is, even if it is published, you can register within a 90-day period. So, and still have the benefit of attorney's fees and statutory damages. So, yes, we love it when photographers register their images. And, what we say is you have a workflow, just like most photographers do for post-production. Make the registration part of your workflow.
Yeah, as Bill mentioned, a good workflow that we've seen is quarterly. Just, every 3 months, go through your work, anything that has been sent off your computer, register that with the U.S. Copyright Office. And as Joel mentioned, that timely registration is extremely important for if there is a problem for you to get the most money possible.
The process of registration as well, it can seem pretty overwhelming and highly technical when you go to the copyright website and you're kind of dinking around there for the first time. Really, if you have somebody that's done it before, walking through it is helpful. But even going through it a first time, there are registration specialists at the Copyright Office that are, in my history with them, have been very helpful in terms of walking people through and helping with that process. The first time is always, it's going to be a bit confusing. It's going to seem complex. The second time you do it, you're going to look at it and say, oh yeah, I kind of remember doing this before. The third time you do it, you're old hat. And so really it's just that repetitive process of it. It makes it very easy to put it into your workflow, and just doing it a couple times is really the best way to get about it, and it becomes very non-intimidating very quickly.
And maybe we can do a program for you guys in the future where we do some of that, because we will often, say to photographers, let our paralegal Lena, who does a lot of copyright registrations, let her walk you through it and show you what you need to do.
That's great. Yeah, we did and Petar, maybe you can be help with this. We did a member open house a number of years ago on copyright registration. Petar, are you able to potentially find that on the blog and put a link to that in the chat? But agree, Jill, I think that the process and technologies have definitely changed. I'm not also sure what the current turn time is on registration, but I know that when I've done in the past, it's been sometimes 2 or 3 months for you to get that certificate.
Well, there were periods of time when it was taking years, but it's gotten a lot better. There's some uncertainty at the Copyright Office these days because our president fired the Register of Copyright, even though the Copyright Office is legislatively part of Congress. But the Supreme Court has said that it's going to take up that issue among many others that it's dealing with soon. So we'll perhaps know the answers.
Cool. I'm going to move on. We can come back to copyright, I'm sure, during the Q&A section of this. There'll be tons of copyright questions. So now we get into the fun stuff, which, as we talked about, is the usage definitions. Here we describe content, and we describe that here as still photographs, video, or animated GIFs, or GIFs, depending on how you pronounce it, that are created for the client in the course of executing this project. We describe the creator, and that's the person or team that has created the work, described here as photographer, director, or videographer. We describe license as the extent of how the client can use the work. And as Andrew was talking about earlier, that's the location or territory. That's the quantity of images. That's the duration and the type of use. And the type of use is extremely important. We'll get into those descriptions and definitions in the next few pages. We also talk here about exclusivity. So we look at exclusivity is while the license describes how the client can use the work, the exclusivity is how you can use the work, which is certainly becoming more and more prevalent in agreements where clients want exclusive work. Now, continuing with the definitions, we describe the type of use. So here we call editorial use is when a publication is using the work to tell a story, and this is either in print or web. Publicity is when the client is submitting the work to a third-party publication for editorial use, and the client is not paying for this placement. That's something, whether it's, I don't know, photographs of a celebrity you shot for a promotional campaign, or photographs you shot of an interior of an apartment. Sometimes that client is then sending them to AD or People Magazine to get stories written on the work. And that's okay, as long as your client has that right to use the work in that way. Now we get into advertising use. And advertising is when the client is paying for the placement of the content. And we've broken that down here into a few different types of advertising. Web advertising, when the client is paying for the placement of a content on any third-party website. Social media, when there's paid boosting on the client's own social media account or placement of the content on a third-party social media account. Print, which is where the image appears in physical places such as a magazine ad or a poster or a supplement of some sort. Out of home, or OOH as it's commonly called, where the content is in billboards, kiosks, bus wraps, bus shelters, or similar display locations outdoors. And this can be digital or print as well. You know, Times Square is all digital now, for instance. Point of purchase or point of sale. This is commonly referred to as POP or POS. And this is when the work is displayed in a retail space to promote a product. So we've seen this anything from, you know, maybe it's a sign saying, you know, hey, here's this new Coca-Cola product, and someone smiling, drinking the product, or it could be, you know, something that's on a shelf in a store promoting the product. Broadcast use is advertising where the work is appearing on a television network, streaming service or platform, subscription video, satellite TV, or cable TV services. So this is, you know, not just the olden days of like, hey, my work is being used in an ad that's on TV. Now it's, you know, we see ads on Hulu, streaming ads on YouTube services, etc. Moving on, we're talking about here is collateral work, which is what we call non-paid placement within the client-owned spaces. So we see this generally as, you know, the company website or their own social media. It could also be an annual report or a company-produced brochure. We define that a little further here into catalog, when the content appears in a printed brochure, booklet, or pamphlet that's being used just to sell or promote product. E-commerce, which is online use where the products are displayed for purchase. And packaging use here, which is where the content is on packaging of a retail product that's for sale. And this is also can include digital representations of that packaging. Joel, could you talk for a minute about the digital representations and how that's important?
Well, I think in general, the use is where the rubber meets the road. For photographers these days, because we see so many different uses. Just so you guys can understand the context. If you look at the Copyright Act has a total of 6 rights, 5 of which apply to still, and 5 of which apply to sound recordings or moving images. But there are always reproduction, creating derivative works, distribution, so distributing copies. In the case of something that's a moving image, it's performance. In the case of something that isn't the moving image, it's display. Right, and then it varies with for musical recordings. But it's reproduction, derivative works, distribution, performance, or display. Okay, so we don't get into this kind of detail. Okay, and however, we see this kind of detail all the time, because I've had many conversations with photographers where they've said, you know, it was understood, not written and agreed to, but understood that if they wanted to use it for social media, they needed to pay me more money because I gave them a discount on this deal. You know, there was years ago, probably at the very beginning of when I was working on intellectual property cases, there was the case involving the New York Times. It was Ticini versus New York Times, which had to do with now all of a sudden there are all these electronic uses that didn't exist before. And, you know, the authors and photographers didn't give the right to use things digitally because it didn't exist before. And now it was being used for that. You know, and there will be other uses for everything. And it's not possible to anticipate all of them. But what you should be doing is you should be describing those uses and delineating what acceptable uses are in exchange for this license and what they aren't, unless you don't care. Okay. And that's also a good answer, right? What I've, if the fee being paid is in exchange for all possible uses, and there's no real interest in retaining any rights, except I encourage you to retain the rights to use whatever it is you're creating for your own portfolio, and get also the rights to use the client's name to associate yourself with having done that work, then grant an exclusive license while retaining the right to use the work in connection with your own promotion of your business, of your work, and to be able to associate the client with you as having done this work for them. The last part of it, you'd think, well, who could possibly have a problem with that? But yeah, I have a lawsuit right now where you know, we sued the defendant for infringement, and they turn around and counterclaim and said, how dare you say that you know, we endorsed you on your website, or that, you know, how dare you use our logo, right? You didn't have any permission to do that. Of course, they had permission to do it from the people at the company at the time, but now the people who are at the company are different and they're not happy. So, so yeah.
Yeah.
But anyway,
So,
Ryan, can I
yeah,
go?
for a second, we see that, you know, a couple of times a month lately in agreements, you know, whether it's a purchase order or SOW from a large corporation, a lot of hotel and hospitality clients that say, you will not use our name, you will not use our logos in association with this work. But you're right. It's something to look out for here too.
I mean, if
when-
you can't, you can't. But I mean,
Right.
try and get it, because unless you don't want to be associated with the client at all, in which case, okay, fine, you don't need to. But I mean, part of what you know, growing in a business is having customers and being able to say, I did this work for this one.
Right.
Bill, go ahead, jump in.
Yeah, so guys, I think a really important point about the definitions in general is that the value of your photographs is proportional to the way the clients are using the pictures. And if you cannot describe in your contract how the client's allowed to use the pictures, you're going to have a hard time collecting on any kind of infringement. So it's just vitally important to have a set of definitions that you can explain in plain English. And we've organized our definitions in such a way that there are groupings. The main groupings are publicity, advertising, and collateral. And the reason those main groupings are valuable is because since most clients just want to own everything, and since it's so difficult to sort of contain the usage, if you can create these big groupings, that gives you the power to add or subtract big groups of usage. So if a client just wants collateral use, it makes it easy to say excluding advertising and excluding publicity. Or if you have a client, if you have a PR client who just needs publicity, you can exclude collateral and you can exclude advertising, and that becomes super powerful. And it not only makes it really clear to your client exactly what usage they have, but it also, if you ever have a dispute in the future, you have legs to stand on. You can, it'll be clear to everybody who reads your contract whether your client has infringed on your copyright or not.
Mhm.
So one of the issues,
That's if you define them well in your terms and conditions.
that's
Yeah.
when I give talks to photographers about licensing, I always pull up the slide of the section of the Copyright Act that Joel was talking about, section 106, and I say, look, I know I'm an attorney and you're not, but really it's critically important, if you're going to be in the business of photography, to really have a good grasp of what exclusive rights the Copyright Act gives you. And the four that I always emphasize that Joel did are display, reproduction, distribution, and derivative works. And frankly, I'm looking at the terms and conditions here. It's whenever you have a lot of definitions like this, and you're sort of, it's almost a cottage description of things. I do think that you're running a little bit of risk in terms of the interpretation that the parties may have, even as well defined as the terms may be. And the best practices that I've always emphasized on all of my clients is, if you go and you have a strong understanding of those exclusive rights that the Copyright Act grants you, then use those terms in your licensing. And that's the most powerful way to really control, those exclusive rights that you have and what you're granting to the other people. So I had one of my earliest lawsuits was between two guys that had worked together for over a decade, and they had an oral contract, and they just sort of buddy, and they were like, hey, maybe we should write this down. And the contract that they put together said, hey, you can use my photos. And they left it at that. And the term use is a very non-defined term. And there was a dispute that popped up over what exactly the extent of use was in the term use. And we went into a 1.5 to 2 year long litigation that got very ugly between these guys that had been friends, just because there was there's confusion about what the scope of the word use was. And if they had adequately said, you have the right to display it for these purposes, or you have the right to distribute it to these kind of people. If you couch your licensing terms in those exclusive right terminologies from the Copyright Act, then that really, it not only clarifies for the parties involved, but it makes it better for, if there is a dispute, to rely on terms that have a lot of case law definition behind them in terms of what exactly distribution is, what exactly display is, that kind of thing, rather than, like, the examples in your terms here, like collateral use, that you may understand that, and you may think that the client understands what that means, but there may be confusion, and it may be difficult to really say, like, oh, everybody knows what collateral use is, because it may not be a very well-defined term in the law. So yeah, I always point my clients, like, use the terms in the Copyright Act, and that's going to be your best bet.
I don't get to work with images in terms of creating them or modifying them or selling them, right? I live in the land of words. And the land of words is not the best place for a lot of this. One thing I would suggest, and maybe you all want to think about at Wonderful Machine, is, make a glossary using images, showing what it looks like. I still am getting catalogs in the mail, but there are an awful lot of people who are in their teens and 20s who don't know, if I refer to a catalog, I mean, the thing from well, I was going to say J. Crew, but I don't even get those anymore. The one up in Maine with the with the duck boots. Yes, LL Bean. Right? I mean, we don't know, and often, because you guys are working in a field where you're visual thinkers and your customers are visual thinkers. So maybe there's maybe using words alone is not the best way to go about this. And maybe some sort of a visual glossary could be helpful. You know, and we don't want to just rely what's out on the internet, especially if AI is making something up, you know, about collateral use, right? Because collateral has a few different definitions, right? Collateral to support a loan is different from collateral, you know, for a written story or something. So, so maybe that would be a good idea. I certainly, you know, would echo what Bill is saying, where the use is very important to value. In fact, we've hired you guys at Wonderful Machine on a number of occasions as expert witnesses in cases where we need to establish what the value is. In the case of, for example, some amazing photographs of hummingbirds or photographs of diesel equipment parts or what have you, right? Because we're not the experts on value, you guys are. And if this is critical to value, then it's critically important that you use the words in the right way.
That's right. Thanks.
Sure.
Okay. Moving on, continuing with the definitions, we now get into display use, which is, you know, as Bill was mentioning, we talked about publicity, collateral, and advertising, but this is display use where the images themselves are the product. So we define this a little more detailed as merchandise use, which is includes items for retail sale or promotion. This could be physical prints or t-shirts, posters, mugs, keychains, etc. We also are noting here that unless it's expressly specified, merchandise is not an NFT. I haven't heard much people talk about NFTs lately, but I know that was all the rage a number of years ago. Public display use is when the content is for decorative purposes and displayed in common area of the client's facility. So this could be an office, factory, warehouse, hotel, etc. Then there's private display, which is when the content is in a non-commercial space, like someone's home or office. And then we get to what Joel was talking about a little bit ago, which was unlimited use, which is anything and everything included above, plus anything else not mentioned as well. This is, you can use it however you want. It could be skywriting or drug behind a plane in the air or Times Square or a Super Bowl commercial.
Skywriting, I haven't that would be some very intricate skywriting. I thought you were about to go you know, for use on the side of a blimp, because that I could see, but reproducing photography and skywriting, unless somebody took a picture of Surrender Dorothy and then they just, anyway. But the use where the image is the actual product, okay? It happens. I mean, it happens a lot. I have this is the Yankee Candle. There's a lot of litigation over Yankee Candle's look and by them, and also this was the image that they didn't have the permission to use in my case. And then you also have, there's a famous case with the photographer who took the picture of the smiling family that was in the picture frame at the store, and he wanted to recover not just you know, a licensing fee for the use of the image, because he didn't authorize the use of the picture he took of the smiling family, but he also wanted all the profits of the sale of the frames. And that didn't go very far, because the judge had to explain to him that nobody buys the picture frame to display the image of the smiling family that comes with the frame. but yeah, I mean, these are important and often overlooked.
Then we get into a couple different modifying terms here. Web, which we can use for, you can say web advertising or web collateral, which is means websites or applications outside of broadcast. Print is another modifier here we're using to specify that that content will appear only in printed, physical, and non-digital formats. Consumer is talking about the intended audience as the general public, and trade is the audience is limited to a specific industry, profession, or special interest group. But we've worked up licensing agreements quite a few times in the past where it's just trade in trade publication, advertising and trade publication, magazines, etc., just to limit where that work can be used.
Those kind of definitions can certainly be helpful, especially if there is a term which could be subject to multiple, interpretations along the way, just to set it out in black and white. As the exclusive rights holder of any image that you take or any copyrighted work that you create, you can really determine in a license who, what, when, where, why any of these are used, and you can dictate those in the terms of a license. So all of these are good examples, but all of these are sort of, at this point, the creator's choice in how to define these terms, right? So you can get as specific or as general as you want. It just comes down to whether the person on the other side is going to agree to that and sign it and then be bound by those terms. So this list is certainly a good a good sort of general touchstone of things, but I think you can, as long as you understand that, you have the right to determine, how any of your images are used by the licensee.
Yeah, and I think that we see a lot of, I don't know what the correct word is, condensing a restriction on big advertising projects as well, because the client knows that the more time that they're using the work, the more they're gonna have to spend. So for instance, yesterday I was working on an agreement for a photographer that has a 21-day license for advertising use. I've done ones in the past, which was a 7-day license for work on a billboard in Times Square. I've done another one in the past that was a 90-day license within a specific location, which was the New York City subway lines, the MTA.
And to Bill's point earlier, just in terms of turning the dial on each of those, the bigger scope you grant it, the more valuable it becomes, and so the license fee should change accordingly. But they're all knobs that you turn in terms of the scope that you're ultimately granting. Geographic, time, the types of use that they can use, any of those. That's what you're doing with these licensing terms, is just sort of explaining what it's your understanding that they're going to use this stuff for.
Yeah, exactly.
I hadn't thought really deeply about the temporal aspect, time. A few of the lawyers and some other folks from our firm are actually listening in, and it's been a while, Brian, since I heard about a license that was for less than a 1-year period, right? I don't know if I've ever heard of a license for photography that was only 7 days long. But come to think of it, it's also been a while since I've been in Grand Central, and there was always that Kodachrome ad in the rotunda in Grand Central that was constantly changing, and and those photographs were always unbelievably beautiful and also really difficult to take, especially at the time when I was seeing them, when I would be frequenting Grand Central, and it was, there wasn't, upsampling software available to be able to do it. You had to take an image that could be enlarged that big and not lose resolution.
Yeah.
the first place. So, but yeah, I mean, think about it. If, you know, because we constantly see cases where the image is used way beyond the term, but the term typically that we see it being used beyond is a 1-year term or a 2-year term. But my goodness, if the term is 7 days long or 30 days long or whatever, you know, yeah, this stuff is extraordinarily valuable and often much more valuable than it appears.
Yeah, the examples I was giving for these very, you know, defined, like the 7-day or 21-day instance I was working on yesterday, those are high values, and the client doesn't want to spend more than they absolutely have to.
Right.
Yeah.
Right. We can afford 7 days, but I can't pay you for 8.
Mm-hmm. Well, so we go into client representative here, which is something that I love here as a ex full-time working photographer. That the client is responsible for providing someone to be at the shoot to deem it acceptable and approved. If not, it's acceptable. So it's basically saying, like, you know, you're there. And then I'm sure that most people on this call have been in a situation where they've done work and the client says, I don't like it. Well, you paid me to do it. You show me what to do. I did it. You weren't there to say otherwise.
I shared, because I don't go on photography shoots that often. I should go on them more. Please invite me. But when I went 2 years ago to CPIC, which is the European Photo Agency Conference, my family was with me, and one day we went, and it was in the south of France and on the Côte d'Azur. Yes, I know, it was beautiful. But we one day we went to like a beach, and there was a photo shoot going on, and my daughters were really interested in other things, but I was just on my phone, I was watching the whole photo shoot because I wanted to see what was going on and who was doing what, and trying to figure out who was the client representative and you know, and why they needed all these people, and it was just fascinating to me because you don't, as someone who certainly the observer of the photography doesn't really think about what goes into it, but that's what we do every single day. We're trying to explain to people who think that the world can be captured on an iPhone, no problem, that, you know, what really goes into the work that you all do. And it's not simple to explain if you haven't seen it.
Mm-hmm.
So more of that. You know, we had a case for Renee Comet, who's a food photographer, and she did a 3-minute video for us of a full 2-day shoot that she did, boiled it down to 3 minutes. And I had no idea about all of the work that had gone in. I knew she was very busy, and I knew she was, you know, she was brilliant, but to be able to see that and also potentially use it to support a client's case becomes really valuable.
Yeah, I love this one, this client representative. I mean, just that, you know, just to let everyone know that the client's going to be there to approve, and if not, the work's acceptable. Let me get into cancellations and postponements. You know, here I think we've all seen that shoots get postponed sometimes just for the client product isn't ready, or the location isn't ready, or the client's aunt got sick, whatever it is. You know, there needs to be some parameters around that. So in this case, we're saying if the project is canceled or postponed by the client is going to pay all out-of-pocket expenses incurred up to the time of cancellation, plus 50% of the creator's fees. Less than 1 week out from the project, if there's a cancellation, the client will pay all out-of-pocket expenses and 100% of fees. If there's a weather delay, all time and expenses incurred, plus costs to reschedule the shoot dates. And this could be crew cancellation fees, travel costs, rentals, etc. Force majeure is something that we added to our terms at the beginning of COVID. and I think is really important. So this is basically meaning an act of God that's preventing the shoot or the project from happening. So in this case, we're very fair that neither party should be held liable for something that's outside of their control, but the affected party will notify the other in writing, and everyone's going to make reasonable efforts to resume the work as soon as possible. And just to be fair, like we're not talking about someone being sick here. We're talking about volcanoes or a power outage or an earthquake, etc. We've clarified this a little more, that if the delay continues more than 30 days, one of the following will apply. So if there's a signed agreement, but no payments have been made, then no one's going to have further obligation to the other party. And if there is money spent, then any money not spent will be applied to the rescheduled shoot, and the creator will refund any unused portion of the retainer. If you begin preparing for the shoot and incurred costs, the client will reimburse you for those expenses. And if the client has already paid their advance retainer but the shoot is canceled, the creator will refund the unused portion of the retainer.
I got to tell you, I'm not a fan of force majeure. First of all, it's in French. My French isn't very good. Second of all, I've seen it used most often by the side that doesn't want to pay. And so, and there was a lot of very creative use during the pandemic. And, the pandemic was a problem in a big problem in a lot of places geographically. And then it wasn't such a big problem, in other places. And it was a big problem, depending on, what the work was and all the rest of it. So I don't know. I think that, power outages, extreme weather conditions. We have a client whose entire videography business is of extreme weather conditions. The force majeure would destroy their business, because that's why they're going out and doing the work. So, but not that that's really relevant to this. But I think it's something to use in some circumstances, but I think it may not. It may work against you. It just depends.
Yeah. So we've set up here to say that neither party shall be liable for failure or delay if there's events beyond their reasonable control. So we've set this up in a way that, like, if a client is paying me to do a shoot and there's an earthquake and I can't get there to do the shoot, they can't say, "Damn it, Brian, we already paid you."
Well, I understand that, and but it's written bilaterally here, neither party.
Mm-hmm.
So one way to deal with this is to just write it to favor the photographer. The photographer will not be liable for failure or delay as a result of these things. And of course, we all, if the problem we have is an earthquake and it's disastrous, I don't think the photographer is going to be unreasonable and demand to be paid 100% if he didn't do anything. But then again, we're dealing with typically photographers are dealing with the other side, which is in a much better position to absorb and to address risk. Okay. And if that's the case, if the person paying is in the much better position to deal with the risk, then why are we giving the other side as big an out as the photographer? Because then that's just going to encourage somebody in the general counsel's department to find the force majeure clause and make a ridiculous argument and force the photographer to take nothing. So, we've been planning this event for a couple of months, and I've been going back and forth with Brian about some of these terms. But I ultimately, I think that everyone's different, right? There are some clients who will come to me and say, this is how I want to approach things. I want to be, I want to give them every benefit of the doubt, etc. And there's others who, who say, listen, they've already had every possible chance. I want you to go in and be a bulldog. So, it's going to be different for every person.
Brian, Rob's got a great question in the chat, and we could probably hold it till after because we're almost through these guys. But Rob, that's a good question, and we'll expand on that when we get to the end of the presentation here.
Cool. Thanks, Andrew. Yeah. So post-production, this is one that I love as well. I think we've all dance a dance with a client where, they come to you and say, hey, it's 4 p.m. on a Thursday. I need all this work done by tomorrow morning. Well, no. So what we said here is, since the exact post-production needs of any project are unknown, we'll work together to find a mutually agreed upon timeline for the work to be done. We've also noted here that if the client is delayed in making selects, sometimes it's better to send a balance invoice immediately after the shoot and then a separate post-production invoice later. I've seen this happen with certain situations where you might do a shoot today, and then the work is done, you deliver the files, but the client hasn't made their selects and might not until March. So in a situation like that, it's like, well, you're not gonna wait till March to invoice for the whole project. We're gonna invoice today for everything that's been done, and then the post-production will be invoiced separately later. Mutual indemnification. Overview of this is that you and the client have each other's backs. If something goes wrong because of your actions, you're going to pay for it. If something goes wrong because of the client's actions, they're going to pay for it. And we get into representations and warranties, which is that both parties are able to enter this agreement without infringing on anyone else's rights. And then attorney's fees here, which is that the prevailing party fees and expenses will be covered if something goes sideways and attorneys need to be involved. Severability. This contract still works even if one part of the agreement is invalid. In governing law, which is saying that this has been entered into the laws according to a specific location, and this needs to be customized for each location here. So in this case, it's for Wonderful Machine, and we're based in Pennsylvania, so this is Commonwealth of Pennsylvania. And then we get into the very important client signature lines. And the signature is important for, extremely important for quite a few reasons. The signature states that all is approved. Without a signature, you don't have an agreement. Another thing I've seen is that most quotes go through various adjustments and revisions, and multiple versions end up being created and sent to the client. So the signature line is, and a client scribbling on the signature line is going to identify that approved version of the quote. The signature holds a document enforceable. So when and if disagreements arise, a clearly written and signed contract is going to give incentive for the client to fulfill their commitments. And if problems arise, things have to go to the lawyers at the courts. A signed agreement is what's going to be there to help you prevail. A lot of times we've seen that clients resist the signature part and will issue a PO on their behalf instead. And that's totally okay as long as the PO terms align with your quote, the usage, the quantity of work, the payment terms, the copyright, etc., and everything's agreeable. And now we've got to the end, and it's time for some good questions and answers. So I'm gonna stop sharing my screen here.
Yeah, thanks, guys. Let's jump back a few messages back, and this might be a good one for Joel and Evan here. Crystal kind of expanded on our questions about copyright registration, mentioning that they registered a group of images yesterday that they are almost positive will be used in a TV show without authorization at the end of the month. Was that useless to do?
So, okay,
essentially asking, must registration be done before those images get used?
Okay, so they're going to be used on for the TV show that's coming. If assuming that is publication, because publication is a technical term, you're fine, because as long as you file the registration within 3 months of the show, whether it's now or within 3 months of the show, the date that you apply, that you submit the application, submit the deposit, pay the fee, is the date that the registration is going to show. So in other words, you don't, you go to the Copyright Office, you say, here's my material, here's my $75. Here's my application electronically. That's the day that the registration will reflect. And as long as that's before or within 3 months after the images show up on wherever they're showing up, streaming, screen, whatever, you're fine.
Well, it would also depend on kind of what happened with those images to get them into their hands in the first place, because an infringing use will not count as publication under the law. An infringer cannot, an infringer cannot be the one to initially publish it. So,
right. So maybe the images were designed for some kind of publicity use. The publication occurred earlier, but you're right. The infringement wouldn't count as publication. But don't wait. I mean, if you know now, go to copyright.gov and get things started. Better safe than sorry.
Hi there. I can expand a little bit more on what I wrote in the chat. It's going to be featured in a Netflix show because the designer the images were originally taken for, she has used for like her website and things like that. But somebody from their production company came to us back in July and asked for usage, which we went through all the terms, but they declined to pay for it outright. So we are pretty sure they're going to use the images anyway. So we went ahead and registered them yesterday with the copyright. But I just wanted to know whether it was a waste of time. So thank you for answering that question.
Never a waste of time. And it's not like, $75 on these circumstances is a waste of money. And if they do show up on the screen and you want to give us a call, we'd be happy to take a look at it.
Okay. Thank you so much.
Sure.
And then I think we got one earlier from Ray Lopez. Hey, Ray. He was asking about anyone licensing unedited images. Brian, that might be a good one to talk about here. What I'm assuming you mean, Ray, is RAWs. And if that has any kind of effect or weight behind it, maybe Brian might have something to weigh in on there in terms of what we've seen here and elsewhere.
Hey, Ray, can you clarify?
Happy to, and good to see everyone on the panel here. There's sometimes I think we've all experienced where, sure, this contract is signed and everything's happy and we'll agree to it, and then they say, oh, by the way, the extra images that we do not select, can we have them, or what can we arrange for us to use these or not use these? They could be just for in-house use. But again, that's the wording that sometimes is weird to me, because at the end of the day, it's still our work, correct? But you still can't control who actually sees them, because somebody will see them. So how would you guys handle that, and what?
Yeah, tell me if I'm paraphrasing correctly. So say the license is for 15 images. Client chooses their 15, but says, hey, Ray, we love this work. We want an extra 5.
Yes, but the extra 5 would not be edited. They would be, let's say, just for their own team, in-house team to review, and maybe, let's say it's a product, let's say it's just burritos, but we shoot all the pretty burritos, but the ugly burritos, they're like, yeah, but this is maybe for the chefs to review every now and again.
Yeah.
And of course, that could be great now, but like in 2 years when there's a whole new team.
Right.
Yeah. Right.
It's going to work in any way, even if it's just in internal review of their burrito making processes, then the client should pay for that work. And you should write a description of the quantity of work and how the client can use it.
Is that similar to B-roll?
I would, yeah, because there's times where, you know, you can call it by different names. I've seen people ask for the any unselected images, meaning that if a photographer quotes a licensing fee for up to 50 selects, which presumably would be edited and delivered as final assets, the client will then say, well, can we also have access to all of the unselected images, meaning any number of images that falls outside of that up to 50 number. And I do think that there's probably value that should be assigned to that access anyway. But I think that the other issue there is that the use is kind of undefined in that situation, because those images aren't necessarily being selected for the same use that you're billing that licensing fee for.
I tell you, I just absolutely love, because, you know, if B-roll isn't exactly it, I just love the idea of calling those images the ugly burrito images. I just think that. Do you want the ugly burrito also?
Yeah.
Right.
Really? We can get the ugly burrito? Yeah, I mean, it's.
I would say you
small
dictate the
additional cost.
Yeah, you dictate the terms of the ones where you want to grant them, you know, wider usage rights, and they pay a fee for that, and say, hey, for an extra, you know, define a small amount, I'll give you the unused ones, but then also in the license fee, you say, for the sake of clarity, you know, this license applies only to these selected images, and, you know, all other rights are expressly reserved by the copyright owner, you know, and if any additional rights, if the client wants any additional rights, for example, to the B-roll ugly burrito photos, those must be negotiated separately. And so
yeah, which is why our copyright clause is so important there, because that covers that essentially. All other rights are reserved, even if those images that are the ugly burrito images sit on a server or a hard drive in the client's office. They're welcome to look at those images, but if they want to use them for anything, it would cost more.
Yeah, and there's no problem with adding extra language into a license like that to really just beat them over the head. Like, don't use these. You know, like, for the sake of clarity, you do not have rights to any of this without any additional negotiation.
Well, it raises a few other points for me other than the funny name to give to it. I mean, there could be, I could imagine, you know, because the reason why these images would show up in the future, as you indicated, would be because there's some turnover at the company, and the images are in the digital asset management system. And so everyone assumes if they're in the DAM system, then they're authorized images and we can use them for everything. So one thing you could potentially do is you could put a term in that says, you know, under no circumstances will the B-roll or the ugly burrito images or anything be incorporated into any digital asset management system. The other thing that you ought to think about doing is if you're using a service that does reverse image search like Pixie or some of these others, include all the images. Don't just include the ones that you know you licensed. Include the ones that you know they got along as part of the deal, because you know those if those show up online, then you do know that there has been turnover at the company and somebody's been using the images that they weren't allowed to use.
Yeah. Thanks, Joel. And then let's get to Rob's question here. And this is, well, one for Brian and me, probably more so as producers. The question is, if the client, the art director, creative director on set calls wrap, and you begin to strike and start to tear down, and then comes back in the room and says, whoops, I just realized I want more images. Can you reset and keep shooting? Does that constitute adding fees or additional time? Obviously time, potentially, but is there additional fees for any additional work there? I think is the maybe what you're getting at, Rob, but feel free to jump in if you want to kind of clarify.
Yep, that's clear.
Yeah. So what I'm hearing, Rob, is, we structure our estimates in the job description. It has a quantity of days and the length of time per day. And it's generally 10 hours.
Yep.
So if there is additional time beyond that 10 hours happening, yes, you should charge them the overtime for everything needed. But as far as just it sounds like a little penalty fee if they say whoops, and then you start, you spend 15 minutes packing up and then say, oh, look, the sun is awesome setting right now. Can you get some photos? I think as long as within the parameters of that length of day, then everything should be fine.
Right.
Well, but I think that this is the sort of thing that sometimes happens unexpectedly. It's as well as the client always does this to me. So, maybe if you know that this is something that in particular you either A, want to avoid, or B, you want to make sure that you and your team are adequately compensated, because you may have additional obligations to the people in your team if you go after a certain amount of time, maybe it's time and a half, whatever. Build it in. Additional requests after wrap are going to incur an hourly rate at 1.5 or 2 times or something.
Right.
Yeah.
So that if you feel like, I really can't say no, at least it's worth your while.
Right.
Yeah. And I agree with you, Joel. If it is a repeat client, Rob, that you have an issue with this over and over again, then I think remind them like, hey, we can jump back in and set things back up and take more pictures, but we'll probably run into overtime. And at that point, it's going to cost you X amount of dollars.
Right.
Yeah. And I think after that here, Ben makes a good point. The concern from that end is that if we're going back to talking about these images that are unedited or unused, they don't want to pay more for retouching or editing. But as soon as that image is sent to the client, it gets put on their server, and chances are they will get used in the future if they want to use them. I think, Ben, that probably kind of goes back to defining the limitations of what use you're providing for the images. So even if they have all of those images on the server, it would be a matter of making it clear whether they have, the rights to use all of those images. And then to Joel and Evan's point is monitoring those, whether that's through Pixie or reverse image search or in any other copyright, management systems that would see to it that they do not get used outside of copyright, as that would be infringement.
Mm-hmm.
Does that make sense? I think, yeah.
Yep.
Yeah, exactly. Yeah, Ben, thank you. That makes total sense. And then I think I was going to add in too, as we're kind of talking about the definitions again, I think one thing I wanted to add in here is that we see a lot is different clients use the same words to mean different things. So that's why it's really important that you define those terms clearly. I think without that, you and the client may think you're like agreeing to the same thing, but are actually miles apart on that same term. And there's very often we see clients ask for vague use like digital or buyout, and those might sound simple, but usually they're interpreted inconsistently across the industry. We tend to avoid buyout and digital altogether because it is kind of vague and not agreed upon in many places. What that means is that copyright buyout, is that unlimited use, is that something else? So yeah, we typically avoid that altogether. But if you are going to use those terms, I think it's important you define them in your definitions, or at least find it a place to agree on them with the person that you're using them with.
the other benefit to it as well, in terms of what I was saying about the like, getting comfortable with the exclusive rights from earlier, and I know it's not part of this presentation specifically, but it's kind of important to note. It's not only from the licensing out perspective that it's good to know that, but also if you are agreeing to a company's terms or like a terms of like a photo competition that you're entering or something like that, if there's a license coming your way, the better equipped you are to understand, you know, when those terms and conditions that come through, that it's really easy for your eyes to glaze over when you're looking at it. The better you can read that and be equipped to understand what they're asking for in terms of, you know, the license that you're granting through those terms. It's just very beneficial as a professional photographer.
Yeah, that's great. And Rob, to your point too, that, you know, at least once, if not a couple times a week, a client will say, hey, we want to buy it. How much does that cost? And the first thing I say is, well, what is that? Can you explain what you mean by that? Because everyone has a completely different definition of that.
Yeah. And Bill, did you want to jump in? You have your hand up. Yeah.
Unmuting. Okay, so just a couple quick thoughts. One is that when I was a photographer, I would frequently have clients ask me for an estimate. I would deliver the estimate. They would accept the estimate, and they would say, "Just don't go over." And I always thought this was like a form of heads I win, tails you lose. And I think it's important for photographers not to go along with that. Basically, an estimate is for better or worse, and a bid is for better or worse. I mean, I guess you could, if you're a photographer, you could agree to give the client a discount if you come in under budget, and you could agree to absorb any cost overrun. But I think it would be smart to either make it a bid or an estimate, but not a hybrid of both. And then another thought I wanted to clarify was when a client is only licensing X number of pictures, let's say 10 pictures, I think it's a good practice to just send them the 10. Don't send them all the pictures, whether they're processed or not, because whatever pictures you send them, they are liable to use. And once the client has the pictures in their possession, it becomes very difficult for you to enforce any kind of misuse of the pictures. And so whenever we're negotiating licensing agreements, whenever possible, we are negotiating for a discrete number of images, and we're delivering those processed images, and we're not delivering pictures that they don't have rights to. One question I had for Evan or Joel was at the top of the conversation, we were talking about the difference, about why it's so important to convey the licensing upon payment in full, because it gives you the leverage to, instead of suing for non-payment, which is a very low payday, you can sue for copyright infringement, which is a much bigger payday, and also provides much more incentive for the client to just pay their bill. But one of the things we sometimes clients ask us to quote work for hire or work made for hire. How do we write language? Is it possible to say this is work made for hire upon payment in full? Because there's a little bit of a disconnect there, because presumably if it's work made for hire, at the moment of creation, the copyright does not belong to the photographer, it belongs to the client. And so if it is truly a work made for hire, does the photographer have any recourse with respect to copyright if the client does not pay?
All right, well, let me jump in here. So the term work made for hire is really not very well understood. In the Copyright Act itself, it says, assuming everyone knows what a work for hire is, in the case of a work made for hire, the employer is the owner. Now, if you're freelance, if you are not employed by the company that hired you to take the pictures, in other words, you're not on a W-2, At the end of the year, any work you did for them is a 1099, but otherwise you're your own boss. Okay. Then you own the copyright. Now, if in an agreement that you sign, you agree that whoever hiring you owns the copyright, then what you are doing is you're agreeing to that assignment. It shouldn't make you necessarily technically working as a work for hire. Okay. Now, what I would attempt to do under those circumstances is say to whoever wants to hire you, whether it's American Express or Joe's credit cards or whoever it is that you're taking the pictures for, what is the goal? What are you trying to accomplish? And are you trying to own the copyright in the images? You want to own all the rights to the images. Is that what it is? And then the answer to that is, well, listen, I'll give you an exclusive license. An exclusive license in copyright is the equivalent of ownership, right? You don't have to actually transfer anything. You will have an exclusive license to these images, which means you can use them for anything. And the only thing that I reserve, if you want to reserve it, is the right to use them for your own portfolio. Unless they have a problem with that, then don't even reserve that. Okay. But then they're getting them for all the things that they want to do. And you don't have this vagary about, is it a work for hire or not? The term work for hire comes into play often when it's trying to be determined who owns what rights. But if you don't have an issue in advance with them owning the copyright and they're going to pay you enough to make it worth your while, then it can be dealt with in other ways. But I understand there are a lot of companies who are like, this is our contract. We're not going to change it. This is what it says. Okay. And then, the question is going to be, well, if you have to accept it, and by accepting it, it means they're going to own everything, then negotiating the appropriate fee for that is really all I can suggest at that point.
But what I'm
a choice.
Sorry, Joel, but what I'm asking is, let's say that they never pay you. Do they still own the copyright?
Well, I would attempt to still do a deal, do a contract that says that ownership of copyright will transfer upon payment. That say, listen, you want to own the copyright, that's fine. You own it when you pay. And that's what it says. You don't intend to stiff me, do you? Right? You're not trying to induce me to work for free.
But
are you?
But if let's say the photographer owns the copyright upon creation of the images, and then they want to subsequently transfer, can you just transfer it by virtue of your estimate, by virtue of your contract? Or if you do indeed own the copyright at the point of creation, do you have to then register the copyright and then do a copyright transfer through the Copyright Office?
No, that wouldn't be necessary. And if the problem is that the company says we own the images under this deal, and they want to put language in there about work for hire, as long as they're agreeing that ownership vests, to use that word, that ownership vests, it comes into being upon payment, fine, then they have paid you. If it doesn't vest until they pay and they haven't paid, then they get sued for infringement in federal court, which is a sufficient incentive to make them pay. And you don't have to deal with state court, where we don't like to be. That's the real problem, by the way. It isn't so much, whether you can recover as much or better under copyright or under a contract. The real difference is that when a company gets sued in federal court, they take it seriously. And that's the only place you can sue for copyright infringement.
Yeah.
So just continue to do whatever you're doing with your contracts consistent with what the rights you're getting, they vest upon payment and not before. And then it's still, in my view, your ability to recover is the same.
Got it.
And while we're on the topic of work made for hire, there's another good question from Rob here about a work for hire language hidden on checks or on the back of checks.
Oh, yeah.
The question that could be here is, if you deposit a check, are you accepting terms printed on that, even if they are buried, not mentioned, or contradicting your previous contract with this client?
This reminds me of a bar exam question.
Yeah.
Because I'm asked that quite a bit. It's like one of those things that people think, well, I can get around it by writing it on the back of the check. Or then the other one that we hear a lot is, well, I got a poor man's patent. I'm like, what? Yeah, no, I just put it in the mail, sealed the envelope, and I mailed it to myself, and I never opened the envelope. So now I have a poor man's patent, which is not that, it's not a thing. I don't believe that endorsements or restrictive endorsements are enforceable anymore since the Uniform Commercial Code was adopted in every state except for maybe Louisiana, and it might even have been. That's my understanding of it. I will consult. We have a lot of young lawyers who took the bar exam much more recently than I did, and I'll ask them, but it's my recollection that restrictive endorsements are not enforceable in any way, so that you can go ahead and deposit the check, take the money you're entitled to, and still sue for the difference, I think. But if it's different than that, I'll let you know, and maybe I will write an article about it for you for the Wonderful Machine website. But because I get great articles every single day, but I'm pretty sure that those aren't enforceable.
Yeah.
And in general, with copyright ownership transfer, whether that's vesting through work for hire or copyright ownership transfer, the law is fairly protective of the copyright owners. It's actually pretty difficult to stumble into an unintended copyright transfer.
It has to be in writing, signed by the author. It's
with very explicitly stated, it's courts have been protective to the copyright owners, which is nice.
Yeah, and I think too, the courts would obviously look at what was agreed to in writing beforehand anyway. So if you have a contract that contradicts what this person has snuck onto the back of a check or something, the courts will probably give you the benefit of the doubt in that scenario. I think we covered everybody's questions in the chat. Not sure if anybody wants to jump in. Joel, Evan, Brian, anybody? Ben, you want to jump in? I see your hand raised.
Yeah, I just had a question regarding this whole work for hire and no licensing situation. It's always been a problem that we've all dealt with for years, where clients don't want to specify usage. They don't want to have any restrictions. I find small businesses are just they don't even know what licensing is. And they're honestly just clueless. And they're like, we don't have anyone to manage a license. We just need the images. And then I've had large businesses, including Fortune 10 companies, massive companies, and they just have so much power that photographers, I'll be bidding a project and there's two other guys or women, whoever, bidding on the project, and everyone's coming at them with no licensing. So they're like, well, I'm not going to license your images, So I think in the past, it's always been an issue of trying to license images. You're always been kind of fighting other photographers who aren't putting licensing in their agreements. But now the question I had for you, just kind of for the panel, more for the Wonderful Machine people, but now that we're not just fighting the photographers that aren't licensing, we're going against AI. And a lot of these companies are like, why am I going to hire a photographer? They want to charge me licensing for every single usage when I can just go generate an image. And this is a dirty topic. It's a sad topic. And I just wanted to get the feedback from Wonderful Machine people in terms of like what you're seeing out there in the market with companies even pushing harder back against licensing because of now not just photographers, but AI.
Yeah, I think it's a good conversation. The AI conversation, I think, could be a 30-hour phone call. But I think that
Yeah, sorry, I know it's a really deep one.
yeah, so licensing always needs to happen. There can't just be no licensing. If the client wants to use the work in a certain way, then that has to be described in some way. It could be described as unlimited, that they can use it in any way, or it could be described as detailed as they can use it on this matchbook for a week, whatever it is, but it has to be described. But to combat against photographers that don't use that language or don't have that stuff within their agreements, I think that the biggest advocate is your quality of work, your portfolio, and a well-written agreement that will impress the client. It sounds, a little silly to say, but language is indeed power and can impress people. And the folks that are hiring photographers, whether those are, producers or creative directors or directors of marketing, they deal with money and agreements all day long, and they should be impressed with your presentation and that you are talking about licensing and that you are talking about quantity of images, because they're going to want to know what to get. I mean, if I was hiring a photographer for a commercial project or for my wedding, I'd want to know what I was going to get. I'd want to know exactly what I was going to get, what time they were going to show up, how long they were going to be there for, what they were bringing, how many people they were bringing, what equipment they were bringing, and how many images I was going to be able to walk away with and be able to use them for, and what I could use those for. So long story short, I think it's that's what's in your corner, is to impress them with your full wisdom of how you're displaying yourself and the work you're presenting.
And it's regardless of whether they want a written license, if they're going to use the work, then a license exists, right? It could be an implied license. And just because it's not in writing doesn't mean there isn't a license out there. And an implied license is going to be subject to a lot more confusion and a lot more, of the unknown out there. So it actually behooves both sides to get it into writing, because it's just, a recipe for confusion and, problems in the future. And the bigger the company, the more they should also want to, have something in writing. A smaller company that just doesn't want to deal with it, you can kind of impress on them like, hey, this is actually good for both of us to have something down on paper.
Yeah. I should just clarify. I do totally agree with that. Usually when I say no licensing, I just meant that they're looking for like work for hire or full buyout. They want to own the copyright. There is still a licensing agreement, but it's always like, we don't know what this is going to be used for. We just need to do a buyout on this and blah, 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 which usually obviously gets you more money. My point was just that nowadays there's not just other photographers out there that aren't charging licensing. We're just dealing with AI. So I know it's a super deep, hard topic to cover in this.
Yeah.
Just wanted to bring that up.
Brian, can I jump in with a couple quick comments? So there's a couple things, Ben. One is that there are some clients, most clients in my experience are conscientious and well-meaning, but there are some clients who will lie to you and tell you that every other photographer is cheaper than you, and every other photographer is not putting any restrictions on the usage. And it's easy to lie because you don't know the difference. You don't get to see those estimates. So what you can lean on is your own experience, sending out lots of estimates and working with lots of clients and getting a sense of your own worth. And you should feel confident in knowing that as an experienced, skilled photographer, you have leverage, and they are talking to you because you have something to offer. And so don't underestimate your own value. You are going to have to learn from experience how much you are worth, and what the market will allow for. But don't be intimidated by clients who will want to intimidate you. And then in terms of AI, I think we're all sort of like floundering around right now trying to figure out how AI is going to impact our industry, how it's going to impact photographers. I think photographers who used to do conceptual photography are going to find that AI is going to be a much cheaper solution. AI is not without its risks with respect to copyright, and I don't know how the people who are providing AI images are going to indemnify their clients for those images, because presumably those images could be actual copyright infringements in their own right. So, but I think there's a lot of photography that is still going to need to exist. Certainly. News photography, I hope, will survive. Certainly a lot of corporate photography that requires us to photograph real people in real situations, in real facilities. I think there's still a lot of real photography left to do.
I'm Ben, I'm looking on your website and I'm looking at your work. And if someone doesn't want to pay you for the quality of your work, and wants to be less professional than you are, maybe it's a good idea to look for different clients. Right? I mean, we all go through this in life. I mean, we're in the service business too. Okay? And one of the things that I found out pretty early on in my career is that clients hire lawyers who are just like them. Now, I think I'm a very reasonable and accommodating, friendly, nice, and ethical person. And so when a client comes to me who is unethical, okay, then they don't hire me, because that's not, that's not me. And if, you have people who are asking you to do for terms that are not reasonable, then in my experience, I say no, and there are more clients out there to choose from. So, it's hard. I get it. Because, we think that the world is smaller than it actually is. But the reality is that the world is really much bigger than we imagine. So I echo the other sentiments. Don't sell yourself short.
Sounds great. Thanks, guys. Yeah, appreciate it.
Yeah, your work's great, Ben. To add on to what I was saying earlier too, I think it's in everyone's human nature line, that we all want the most we can get for the least amount of money. And that's fine, but you're presenting your clients with great work. And if you're compounding that with being an awesome person and presenting a well-written project agreement, it's going to be a full impressive package that the client is going to be willing to potentially pay more money for, or have licensing described where another photographer might be the same cost as you, but not just say photography X amount of dollars. So use those things to your advantage.
I think we've covered everybody's chat questions as well as raised hands. Does anybody else want to jump in with anything before we come to the top of the hour here?
Awesome. Well, thank you again, everyone, for joining us, and Joel and Evan for being such an integral part of this. Much appreciated. As I think Bill mentioned in the chat, this is recorded. We will have this up on our blog, and we'll be sharing it with folks as well. And we're looking forward to doing this more often and hearing from folks too. So please reach out, whether that's SRP Law or us, if there's anything we can do to be a help with your agreements and and understanding more about licensing and copyright.
Thank you.
And Brian, let me just say that I'll stick around if anybody has any questions about Wonderful Machine, anything you want to talk about. I'll stick around for after the show here.
I was trying to remember, Bill, where did the term Wonderful Machine for a camera come from? Because I was reading a Len Doughton book, and he wrote spy thrillers in the 60s. And the term was used in one of his books, but I don't know if he was the originator of it.
No, so Wonderful Machine. I'm actually looking up. We have a blog post called Origin Story. So Wonderful Machine refers to a chapter in a book by Laura Ingalls Wilder. When I was a kid, here I found the link. When I was a kid, there was a TV show called Little House on the Prairie.
Yes, I was a kid then too.
And there's and one of the books. This was a series of books. One of the books was called Little House in the Big Woods. And when my daughters were about 5 years old, and they're now 25 years old, I was reading them this book, and we came to this chapter called the Wonderful Machine. And I was at that time trying to figure out the name for our company, and I thought that's a clever name. And I was able to secure the URL for that. And so to me, Wonderful Machine could refer to a camera, which is certainly a wonderful machine, but also I wanted it to refer to our organization that we were building, that I wanted to be a wonderful machine. And so it was sort of a catchy title.
Yeah, it's great. The term shows up. No, it wasn't. I'm sorry, it wasn't Len Doughton. It was William Boyd. In his book, this is reverse, Sweet Caress, which she's holding a camera in.
Huh.
So yeah. So yeah. I thought that might be a little bit too obscure for it to have been the origin, but thank you for that. And
Sure.
It is true. When you first encounter a camera, I remember thinking, especially when I had a dark room, that was a wonderful machine.
Mm-hmm.
Yeah. Thank you again. And I think the idea of doing a glossary and having some visual examples of different licensing would be great. And we'd love to participate.
Okay.
Yeah, I was going to mention that. I think that might be something we could all pull together at some point and share with everybody who
Sure.
was
And then
excited.
it makes, and then your contracts would be simple, because all you would need to do is refer to the web link, and the definitions of all these terms are up on the internet.
Yeah. Okay. Well, Joel and Evan, thank you so much for your time today. Really
My
appreciate
pleasure.
it.
I don't know if Evan can stick around, but I need to run. Thank you, and look forward to speaking with you soon.
Sure.
Thank you, Joel. Thank you, Evan.
Everybody. And then anybody who's still around, just keep in mind the blog article with the expert advice for our terms and conditions is linked here. Check that out. Kind of covers a lot of what we just talked about in the presentation. And, reach out to Joel and Evan, or Brian and I, or anybody else, at Wonderful Machine or at SRIP. We're happy to help out and answer questions further, or work with you and help you out however we can.